that, go through it all. So I want to make sure he has time so we're not hearing a complaint about that.
As long as possible, within reason.
Yes.
It has to be reasonable.
You didn't have to explain that when I asked you what they going on without victim.
Oh, excuse me. Let me put this on the record. I did explain that I guess it's hard to understand the various exceptions to hearsay and how in certain instances they can go forward without the victim. I was trying to explain, and then the people gave me a case I haven't read, but I was trying to give him the site People versus Only 327 Mishap 319. Would the court please explain to my clients certain instances where they can go forward without the victim? Excited utterance, mental state.
There are exceptions to the hearsay rule. Given that this is a domestic violence case, there's a statute which would apply, which would allow them to proceed with police testimony. Also, and I don't know if this is the people's intent, they would file a motion to proceed by forfeiture, meaning that because of, the simple way of putting this, because of your wrongdoing, the alleged victim is not present. So the people would, in that instance, not be punished by what is your behavior, or at least allegedly your behavior, Mr. Epps, and so would be allowed to proceed. That's kind of a nutshell version. I mean, there are a little bit more technicalities to it, but I think that
one of the technicalities would be MCL 768.27C, and as I indicated, that case, People versus Only 327 Mishap 319, and the various exceptions to the hearsay rule. That might be excited utterance, present sense impression, mental state of mind.
Yeah, I mean, it's all of that kind of thing.
Do I got a right to cross-examine my accusers?
You know what? Here's the thing, sir. That if you're talking about the right to confrontation, there's a statute particularly on point where that may be forfeited because of what is alleged to be your behavior. That was the last thing that I brought up.
What do you mean by that, sir?
I am not here to give a law school class, although I could. I'm not, I know, but I'm just saying that is very technical. That's why you have an attorney.
But I couldn't explain it anymore, and that's why I brought it up.
You just broke down law school for her. How am I different?
I didn't break down law school.
Okay, I'll tell you.
He asked the question.
We have told you.
All right, I'm done. I'm going to set it for exam.
I'm going to go to the jail today, so I will. I'll tell you.
Preliminary examination in this matter, because the people may have a motion. I'll set it for September 17th, 2020.
Okay, just one moment, please. Don't turn your back on it, please.
September 17th, 2024.
Yeah, but he might be if you like.
9 a.m. That's before me.
Thank you.
When?
September 17th at 9 a.m. Oh, wait a minute, excuse me.
That's 3 weeks.
Yeah, September 17th, I can do that, but not the 8th, because that's the judge's calendar. And I'm a deferred professional. There are some parameters, and you are not being. Oh, that's the new thing in the jail I'm learning, that I'm being.
And I would anticipate the people's motion, so we'll try to hear that.
It's the new buzzword in this world, and everything is a violation of that.
Of what?
Speedy trial. That is the new buzzword in the jail.
Can I ask a question? What is about what's going on in the jail? Speedy. None of this particular about my case.
You just said you had a right to speedy trial.
I didn't say. I asked why so long. I didn't say nothing about.
It's not a violation.
I asked why so long. I didn't say nothing about no speedy trial. Like Judge Sim, this is where we having a conflict at, sir. I'm asking about my case, and it's everything other than the case. I don't want to talk about nothing but this case.
Okay, but Mr. Epps, hold on, slow down. You have two things now, which have, hold on. You asked me a question, but you're operating off of a premise that isn't going to work. So here's the thing. You had the one case come up. We then had the hearing. There were allegations made, and this is where the complication comes in. There are allegations that are then made that there is phone contact and other communication. I don't know for sure. The allegations have been made. There's evidence of the phone calls. So that's where we are. What the problem then that happens is that leads to additional charges, which then not only is there now this additional felony, that clearly will have an impact upon what the first case that you came. That's what counsel's trying to get through. She's got to get that information. That then leads to other things.
Okay, I understand that. She's not explaining that, sir. That was simple things to understand.
I accept.
Okay.
We're good.
I can't get in between every counsel and attorney and defendant.
Thank you.
And I'm not trying to do that. I'm just trying to explain the process. And I've got to, Mr. F, I've got to be fair to both sides. So I got to have it worked out. You would have had an exam before now, had this not come up. Okay. So that's the reason for the stretch out in time.
Okay.
Also, the other thing, so that you just understand, it's not anybody trying to delay anything. Because of the issues that come with that, and sort of this complicated thing, I won't say it's complicated, but it's a thing where they're going to proceed, presumably, and I don't know, they know this for sure, without the witness. Your counsel has to try to do some things. I've got to give her time to do that for your protection.
Okay.
So it's not trying to stretch anything out. I'm just trying to make sure everybody has an opportunity to do what it is they need to do. It's really as simple as that.
Thank you.
Can I say one more thing, sir? Yeah, my last court hearing that I will be able to get a hold to her when y'all took my phone.
Excuse me?
At my last court hearing, y'all took my phone. Y'all told me I'll be able to get a hold to her. I'm not able to get a hold to her.
You should be able to call your attorney.
We've talked.
I'm not able to get a hold to you.
I don't.
But we talked. He's saying he had to go in the three-way, but we talked.
I'm not able to call her, sir.
You should be able to contact your attorney.
I'm not able to, sir.
I can't. Did somebody at the jail make sure that can happen? Ms. Ford, check into that.
All right.
I'm done here, folks. Bond continue.
In this tense and layered courtroom session, what began as a procedural hearing quickly escalated into an emotional clash between a frustrated defendant, his dedicated attorney, and a judge forced to balance legal precision with rising tension. The defendant, already facing domestic violence-related charges, grew angry when he learned a second case had been filed against him for allegedly calling the victim from jail, a move that created new evidence, new charges, and new complications. His attorney explained the need for additional time to review jail calls, hearsay exceptions, and a likely motion for the prosecution to proceed without the victim under Michigan statutes like MCL 768, 27C, and forfeiture by wrongdoing. But the defendant insisted she wasn't fighting for him. The judge stepped in, defending the attorney as a skilled fighter, bound by legal rules, not emotion, and explained that his own rulings were designed to protect the defendant's rights, not delay his case. After clarifying how the new charges affected the timeline and why a preliminary examination had to be set weeks out, the court scheduled the hearing while also addressing the defendant's inability to call his lawyer from jail. But the emotional weight of the day didn't stop there. In the separate eviction case heard immediately after, the courtroom saw one of its most heartbreaking moments of the year when Shauna Zerley, exhausted, sick, and struggling to speak through tears, pleaded with the judge to reconsider her eviction. She insisted she paid rent twice, showed varying online ledgers, and described break-ins, stolen medication, and harassment by park management, but the judge emphasized that sworn testimony from November 14th showed no payments received since June, even when Shauna whispered, "I probably have a year left." The judge remained bound by the law. Her evidence was late, unclear, unverified, and her motions were denied. The judgment for possession remained in effect, leaving her to face homelessness and the loss of her trailer. She said she had nowhere to go, no strength to fight, and no one to help her, but the court could only repeat its legal limits: pay the nearly $3,000 owed, or the park can remove the home. As she was escorted out, the judge admitted this was his second major crisis of the day. A reminder that behind every ruling lies a human story the law cannot always bend to fix. For more information, like and subscribe my channel.